mention and
Yes,
on restoration application, my lord,
give
and
it.
another inclusion on the similar foot.
Give all inclusions, give.
One matter for judgment, madam. Here is concluded in the month of September 2024, madam. 10 months already, madam.
Yes. No, there is something wrong. You are mentioning a wrong case. We don't have any judgment pending since September 24.
FAT 536 of 2028, madam. The state is the madam appellant here, madam.
There is something wrong.
Can we check up, madam?
You check up first.
I have checked up.
We know for sure there is no matter pending.
না, না, দেখেছি, আজকেও এখনো দেখা just now I have seen, madam. 2018.
State of West Bengal versus
Shaheen after.
Ghazala Sahib.
You give it, we'll see.
Madam.
Sir, item number 169. On that part of vacation, now state certificate is no longer part is permanently missing. For field formulation, food, solution.
So what happened after that? What is the, it is on the list. So we are taking up, it will come in a few days. Don't worry.
Because I have very generic basic point of law involved.
Yesterday we said.
Lordship will be taking from 92.
7, 8 and 9. So why are you mentioning it is at the top?
Your Lordship has given.
So why it was not taken up? It must have been called. Today it has come. And he's saying that it is pending for judgment. What is this? Where is he? Where did he go?
Inform.
Give it to him. Pending since 24 for judgment.
My lord, may I be permitted?
Your Lordship, this matter was moved yesterday for leave. We have got the order copy.
Where is the other side? Because if it is we have notified that we are, see, actually because the cases at the bottom, they are not being taken up. So we are proceeding forward now. So you see if he's here, you mention at the time of rising for recess. Yes.
Your Lordship, yesterday we had come to take leave without the certified copy. We've got the certified copy. Could we move today at 12, Your Lordship? Because it is
What is it?
new matter pertaining to admissions for setting of examination by the.
No, that we have seen. There is no urgency.
My lord,
You are challenging questions and all that. In one day, nothing can be done. Yes.
my lord, there was one WPDRT matter which was filed before this honorable bench. My lord was pleased to release the matter on 11 June 2025 for want of determination. But the confuse arose because we have filed it under Article 323B of the Constitution of India, but wrongly the copy which has been served upon my learned adversary and the copy which we have written, that was written Article 226. That was a mistake on our part. We have checked it out. It is filed under 323.
Yes, there was one matter arising out of which tribunal?
The DRT, my lord, DRAT, challenging DRAT order.
No, but we have already released the matter.
Yes, my lord, because the copy which has been served upon my learned adversary.
No, we said let it be discussed before the. Once we have released, then how can we recall the matter?
My lord, we have checked it out with the learned registrar below.
You were represented on that day. The learned counsel said yes, it should go before another bench. Now you are making another submission. Once we have released it, how can we recall it, sir?
My lord, we have explained it to my learned adversary also.
We don't know what you have done after the court is not relevant. What happened in court is relevant for us. In court, both of you agreed that no, it is not to be before this bench. We released it. So how can we recall it now? Please try to understand what we are saying. We are not saying that you are wrong. How can we recall it once we have released it? We have only said it is to be listed before the appropriate bench.
Yes, my lord, but there is
Therefore,
no other appropriate bench.
We
at the-
don't know. We don't know. How can we? Please try to understand what we are saying. You are a lawyer and we have to tell you 10 times. It's a very difficult situation. Yes.
Lordship, my lord, I mentioned a matter yesterday at the before Lordship realizing, my lord. My lord, it's item number 22 in days list. My lord, matter was called on Thursday. My lord,
22.
22 in days list, my lord. My lord, matter relates to, my lord, study leave of a doctor.
Oh, yes, you were mentioning yesterday.
Yesterday, my lord, I had a talk with my other side, my lord, Mr. Arjun Rai Mukherjee. My lord, he had some problem today itself, my lord. He said it can be, if matter is taken up tomorrow, my lord. He won't have an issue with this. Lordship, kindly fix up tomorrow, my lord.
Tomorrow it will be taken up. 22, tomorrow it will be taken up. Give a slip about giving today's date.
My lord, may I be permitted to mention this matter? My lord, the matter was in the list on 9 July 2025 before your lordship as item number 156. But I have received a SMS. The matter has been fixed on 10th. Well, as usual, the message has been served. But on 10th and today is also the matter is not on the list.
It's a fresh case.
No, my lord, it is a hearing matter. It's a long pending matter, my lord.
So it will come.
Your inception of your lordship.
Just take the slip,
Termination.
let it come on the list, include it.
My lord, it is not the come on the list, my lord. It was in the list. It was in the list on the day on
Understood
Friday.
what you, yes.
And I have
Call the
received a
Your lordship,
message
your
that the
lordship,
matter is shifted
Your
to
lordship,
10.
may I be permitted to mention, your lordship, this matter was
So lordship,
mentioned before
We
vacation.
have understood what you are saying. How many times you will tell us?
yes, the matter is
Yes.
This was mentioned before your lordship, so I was asked to come after the summer vacation. My junior had mentioned on 19th of June, your lordship, for early hearing. This is related to one review application which was allowed. Your lordship, any day as per the convenience of your
Next
lordship,
week,
next week.
Monday.
Deeply obliged, your lordship,
Monday.
deeply obliged.
Number 92.
Lordship, Mrs. Chandrayalam is appearing on behalf of the petitioner, praying for not this week.
Number 93.
93, my lord, I am appearing for the petitioner, my lord.
But I appeal for the respondent, private respondent.
So I have prayed before the learned tribunal some more time to conclude the disciplinary proceeding, my lord. Learned tribunal did not allow and directed to pay entire amount, my lord. Allegation is this, my lord, disproportionate of fund, my lord, 2,66,000.
Which order determined the time for concluding the proceedings?
That order they have not
Page,
affixed, my lord.
lordship, page 42. Page 42 is the order, my lord. And relevant portion, page 46, my lord.
Forty-seven.
47, my lord. I am praying some more time, my lord, so that I can. By this time, inquiry officer, the Vigilance Commission is the inquiry officer, my lord. They have
January 23.
inquiry officer is the Vigilance Commission, my lord. They have concluded the report and recommendation, my lord. We got it on 15th Lordship, 30th October 2023, my lord. And thereafter, date 21st October 2004. Lordship, kindly come page 62, my lord. We have communicated to our learned counsel, my lord, to submit the issue, my lord. Page 62, my lord. And accordingly, learned counsel submitted before the learned tribunal.
It's taking you forever.
Lordship, page 62, kindly consider page 62, my lord.
Yes.
we have received the fresh inquiry report and
That is
recommendation,
of
my lord.
November, sir. That is of November, 8 months back.
Lordship, thereafter, we have prayed before the learned
Even
tribe.
today, you have not done it.
Since the order is set aside, my lord, and direction is passed, some time may be allowed, my lord. We shall conclude by time bound manner, my lord.
Charge memo of 2013.
This order is passed on 6th November 2024, my lord. Impin order, my lord.
Yes.
After receiving the recommendation and report, my lord, we have prayed before the learned tribunal
Yes.
to allow some time, my lord. But they have not allowed, my lord.
No, the order does not reflect that you have placed this document 6/11/24.
I have verbally have said, my lord, that stated, my lord. But in my place today, Mr. Sayon Bhattacharya, learned counsel, having taken instruction, is of the opinion that the actual conclusion of the proceeding may take further few months, my lord. Few months.
But you have not placed this document. Few months means what? First time you were allowed 4 months, I think.
4 months, my lord.
Then you waited for a year, more than a year. Then
Since
again you were allowed 2 months.
inquiry conducted by the State Vigilance Commission, my lord. We are the disciplinary authority, my lord.
So it is open to them to do whatever they want.
No, my lord. Charge officer took at least, my lord, thrice or fourth time occasion they took adjournment, my lord.
When did this person retire? When did he attain the age of superannuation?
2018, my lord. 31st January 2018, my lord. At least 4 occasions they took adjournment before the inquiry officer,
Yes.
my lord.
4 occasions
Lordship.
they took adjournment.
And thereafter filed
They have
2
committed
original
a big
applications.
sin.
2 original application and 1 WPST also filed before this.
They have committed a big sin
Oh, my lord.
by taking 4
I'm taking only
adjournments.
4 months time, my lord, to conclude the inquiry proceeding, my lord. Allow me only 4 months time, my lord. In a time bound manner, we shall conclude, my lord.
Sorry. We have heard the Learned Counsel.
Yes, sir, Mr.
94.
My lord, 94 and 95 are both identical matters, my lord. My lord, pursuant to your lordship direction, my lord, I am filing my supplementary affidavit, whereby your lordship has, my lord, directed, my lord, what happened to the Kerala decision, my lord, I have given, my lord.
Oh, it is that matter. Two cases. Which was that matter yesterday?
Yesterday was, my lord, it was item number
77.
77. 77. But my lord, kindly says, my lord, here, my lord, the instruction is there, my lord. My lord, instruction is there, my lord. If your lordship can take, my lord, page 8 and 9, my lord. These are relevant, my lord.
Affidavit, my lord.
Page.
What is affidavit? Second para, my lord. An agenda will be placed before the central board along with the decision of the honorable CAT in the bench, way number such and as well as the high court order. That means, my lord, executive has more powerful and superior than the judicial order.
Yes. Friday for orders. Parties have been heard.
93 and 94.
Yes, both cases. Who is in 93? First 93 has been called. Anyway, we can dismiss. 93, 94.
Yes,
94,
served affidavit of
94 you give your appearance so that we know in which case you are appearing. 94, 95.
Yes. Sir, আমাদের 93. Another 93 should আমাদের 94.
490 is already defined. 490, I am 95.
You are in 95.
95.
Who is in 94? Nobody. All right.
He has appeared on that.
Not required. You are here. It is your
He
case.
has appeared on that day, first day. Now he is saying that he is not
No,
appeared.
no. Actually, my junior erroneously appeared. Actually, I have no overall knowledge.
So 94, 95. Huh?
Hey,
Good.
Please, sir.
any. দাদা ওটা চেঞ্জ করুন 495.
Call the next, please. Both cases heard to parties for orders on Friday.
96.
Matter below, I am for the I have filed an application for substitution on the date of the respondent number 1. But kindly see the page 11 of my substitution on order dated 5th May 2025.
There were two petitioners in the tribunal.
Number 1, Milord, due to death of the respondent number 1, Milord, we have filed an application for substitution in terms of your lordship's order, Milord. And let this happen.
Where is the details?
Detail, Milord, your lordship will find from the page substitution application, you will find.
There is a wife and son.
Yes.
And what is, when did he pass away?
Page 3. Wife of.
No. When did the respondent pass away? What is the date of death?
Date of death of
Anyway, yes.
Yes,
What word?
No. So I have wrongly blooded. Your petition that during the pendency of the read petition has expired. No, that came to know, Milord. It ought to came to know.
In fact, he passed away just one day after the order of the tribunal. Tribunal's order is 11/5/23, and he died on 24/1/20. So he had died even before the OA was disposed of. What is the date of death? Is 24/1/23.
24/1/23.
But the tribunal's order is of a later date, 11/5/23.
Yes. But that was your lordship kindly see the 11/5/2023.
Correct. So he died before the tribunal passed the order.
That was not what our knowledge, Milord. That's why, Milord, we have served the copy. Then we came to know that the return back with endorsement that died.
The petition is by you.
The order was passed, because there is no reflection, Milord, that.
Yes. So this order was passed by you. Who is appearing for the respondent?
Copy, sir. Copy, Ujjal ছিল না? Ujjal ছিল? Ujjal sir? Last talk is order to দেখি না।
He is no more.
None appears, Milord, last talk is order your lordship kindly see the page 11 up. And before Cat Miller, we came to know S. Dotto.
Hmm?
Some Dotto, Mr. Dotto is there in Cat.
We are informed that
Ninety-four, 95, issue are same.
The issues are the same.
Same Miller.
It was my lord's pleasure.
we are taking up right now which matter?
96 was taken up.
You are in 97.
Lordship, it is an application which is preferred by the Union of India.
Yes.
But the subject matter is common. So it was your lordship's pleasure on the last occasion that your lordships would hear it analogously. So my lord may fix up this matter also along with.
Yes. List along with just one order, list along with the first.
Good.
98.
None appears for the petitioner. When the matter is called on to
100 is my approach. 100. That I'm led by Mr. Ekramul Badi.
Yes, what is the issue?
The respondent is not there, but my lord, the issue is, my lord, the state, my lord, there was an advertisement published for the purpose of, my lord, before taking to the point of law, my lord, may I give the brief fact? My
Yes,
lord,
please.
in the year 2016, my lord, there was an advertisement published for the purpose of appointment of inspector of drugs. My lord, I applied. Now, my lord, at that point of time, so far, my lord, the initial criteria goes, the total number was, my lord, 85. Now, my lord, out of 85, I secured 81, but, my lord, I found to be, my lord, ineligible. Now, my lord, there was, my lord, other similar candidates, my lord, who applied before the tribunal. Now, my lord, tribunal initially found them to be, my lord, unsuccessful candidate, and, my lord, who is assailing, my lord, the process of recruitment, that was rejected. My lord, they preferred, my lord, application before this honorable court, like me, my lord, I have come. Now, my lord, there, this honorable court was found, my lord, that there was a change of marks in the midst of the procedure. My lord, 85 was turned out to be, my lord, 100. Now, my lord, that change, my lord, this honorable court has found, my lord, to be not justified. Now, my lord, this honorable court has held, my lord, 85 is to be taken into consideration to be total marks. And if that is taken into consideration, in that case, my lord, those petitioners was found to be eligible, and my lord, they were directed to be appointed. Now, my lord, I am in a better position because those three petitioners, my lord, who were appointed, my lord, my marks is better than that. My lord, I approached before the tribunal. Now, my lord, the learned tribunal held that, my lord, that I am delayed in, my lord, approaching the learned tribunal. My lord, held to be, my lord, be to be a fence sitter, and, my lord, my case has been turned down. My lord, today, my point before your lordship is that, my lord, whether I am entitled to get, my lord, the similar benefit, my lord, under Article 21, and, my lord, the order that was passed by this honorable court was a judgment in rem.
Yes.
Now, Lordship has seen, my lord, the order by which, my lord, my prayer has been turned down. Now, my lord, mainly on two grounds, my lord, it has been turned down. Now, my lord, the main thing that has been held against me, that, my lord, it has been held to be a fence sitter.
Yes.
Now, if your lordship kindly look at, my lord, the time schedule through which, my lord, I had to go through. My lord, it was in 2016, my lord, the advertisement was published. Now, my lord, 2017, my lord, the examination has taken place. Now, my lord, 2018, my lord, those petitioners approached before the tribunal. My lord, the decision of this honorable court holding that, my lord, the procedure that was opted by the authority was wrong. That came in the year, my lord, 2021. My lord,
2020.
2020. I'm sorry, I remain correct. 2020. Yes. And my lord, I approached before the tribunal thereafter.
In 21, you filed your RTI.
Yes.
After 1 year of the High Court's order.
Now, my lord, I came to know, and my lord, then, because otherwise,
No,
my lord,
you did not.
It was not within.
You have started the thing by RTI.
Yes.
You have not started it based on the High Court's order.
Correct. My lord, I am seeking the similar relief, my lord, on the basis of the High Court's order. Now, my lord, today, my lord, so far the point goes, my lord, if, my lord, the decision of this Honorable High Court, my lord, operates as a precedent or not, my lord, whether that's a judgment in personam or a judgment in rem.
No, that's not the issue. If it's a judgment in rem, you need not be here.
Well, that's what I am saying.
Then you are not required to be before the court.
My lord, I say, my lord, that's a judgment in rem that should have been given. My lord,
then you should have filed a contempt.
My lord, I
the
can also
question
come
of-
by. I can also come by a writ petition. My lord, there is no difficulty. My lord, it's not a.
Let us see.
My lord.
For a judgment in rems implementation, one has to file another writ petition. Let us see the law.
My lord, instead of contempt, I can file a writ petition.
Let us see. Let us see. You have said that. Now let us see the law.
My lord, for the time being, my lord, I thought, my lord, I was conveyed that, my lord, your lordships are disputing, my lord, that the judgment passed, my lord, it has been heard by your lordship on the earlier occasion.
We are not disputing anything. We don't remember anything when we heard on the
That's
last.
the difficulty, my lord. I was conveyed that, my lord, whether it's a judgment in rem or not, my lord, is the point I am supposed to.
The issue is whether you are a fence sitter or not. That is the only issue.
My lord, if we look into, my lord, the judgment
question
of
of
Rushdie Bhai,
judgment.
my lord, of the Honorable Supreme Court, my lord, I will be relying on that judgment. My lord, kindly consider this.
Which judgment?
My lord, the judgment of, my lord, Rushdie Bhai, Jagdish Bhai Patha. My lord, this is 22 SCC online, my lord, 641. এটা একটু দিন তো। Now, my lord, in this case, my lord, may I point out, my lord, the paragraphs relevant will be.
Just a minute.
Yes.
Yes.
There is one, my lord, particularly, my lord, it's in paragraph 17, my lord has been pleased to see, my lord, paragraph 22.3 of the judgment, my lord, that has been quoted. My lord,
22.3.
22.3, the last page, if your lordship kindly. It's a quotation of the earlier judgment. That is in paragraph 17, quotation of that paragraph of the judgment considered. However, this exception may not apply in those cases where the judgment pronounced by the court was judgment in rem with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon the policy matters. Here, my lord, the policy matters, like scheme or regularization and like. Then, my lord, it has been quoted, my lord, such and such. On other hand, if the judgment of the court was in personam, holding that the benefit of the said judgment shall accrue to the parties before the court, and my lord, it is not the case, my lord, in our case. So, my lord, the first part, my lord, really. And my lord, so far, my lord, this case is concerned, my lord has been pleased to see, my lord, in this case, my lord, the cause was in 2010. And my lord, the challenge was preferred, my lord, in 2017, after 7 years. Even then, my lord, the Honorable Supreme Court was pleased to, my lord, given, my lord, the relief, my lord, to the petitioners. My lord, in our case, my lord, if your lordship kindly take it into consideration, 17, my lord, and 21, my lord, we have approached before this Honorable Court. Taking, my lord, the time gap, my lord, that was taken into consideration, my lord, I am not that far. My lord, I am in a better position. Now, my lord, so far, my lord, the order that has been passed by this Honorable Court, if your lordship kindly takes once, my lord, page 53 of, my lord, my paper book. Page 53, if your lordship kindly comes to. Now, what has been decided?
Yes, we have seen that.
Yes, my lord, that part, my lord, it states.
Under the rule, it was to be for 85 marks
and
conducted by the board.
Fine.
They have added 10 marks for experience, 5 marks for government experience. So now the evaluation is on 100 marks.
Fine.
The court has held
So,
it
Lord,
could
the
not
policy-
be done.
Could not. So I say, and my lord, one more judgment, if your lordship so
Yes.
pleases. Lord, only on the point, my lord, that it becomes a precedent. My lord, it is, my lord, 2023 volume 16 SCC, my lord, 458. My lord, the relevant paragraphs will be, my lord, in this judgment, my lord, 5 and 6.
Yes.
এই দুটো একটু দিন এটা only this is mainly on arbitration, not on, my lord, service matters, but for the principle of law, my lord.
How this is relevant?
My lord, only that.
Where is the issue of ratio decidendi in this case? Why are you referring to this?
Well, only for the purpose that, my lord, that principle of law has been decided, my lord, by the Honorable High Court already. That, my lord, that should not have
Who
been
is
done.
saying not decided?
I'm grateful. I'm
You
grateful.
said it is not decided.
My,
Why do you need this?
my,
Yes.
that is the short point.
Can you see page 71, order of the division bench? My friend is considered
71 is
the requisition. Judgment of the division bench, page 6.
Yeah, we have read it at we have read this order at page 50. Yes, page 50.
71.
71, two of the petitioners were left aside, my lord. They were not similarly situated. Their case was taken into consideration later on, my lord, 2 and 4. Now, my lord, those were taken into consideration. I'm grateful.
You were making submission. He was not saying anything. Now, when he has started, you are interjecting. You think he will tell us something wrong? And if he tells us something wrong, you will not get an opportunity.
But
yes.
Hold that the tribunal does not justify the claim of the petitioner wants. But if the decision is taken, and so far the petition of 1, 3, and 4, how it can be said judgment is then? And but so far as 88 post is concerned, that has been filled up.
Yes, the division bench itself has taken note of the fact there is no more vacancy.
No more vacancy.
Therefore, it says we are not interfering with the process. Yes, take down. Anything in reply?
My lord,
Order
only
Leonard
one.
Kam. Yes.
My lord, if it is found, my lord, Article 21 says that I am entitled to get the equal benefit. The Honorable Supreme Court.
Article 21 is involved.
My lord, I'm saying so. My lord, 14 also. 14.
How Article 21 is involved in this case?
My lord, I am
It's
supposed
a
to.
service matter. You are claiming equality under Article 14 and 16.
Yes, my lord,
41 is not an issue arising in the
My
present.
lord, the Honorable Supreme Court, my lord, the judgment that I have given to your lordship in paragraph 7 has said that, my lord, even if
that judgment you have already cited, we are saying you want to say anything in reply. 7 and 22.2, you have already
my lord,
cited.
if it is the point that, my lord, just because the vacancies are not there, otherwise my entitlement is not in dispute. My lord, for the consequences, I cannot be deprived of the benefit.
Heard Leonard Counsel for the
No, here for the response.
Yes, one or two long letters. But I'm appearing for the Union of India.
When the matter Yes, where is your report?
The disciplinary proceedings, my lord, was pending against the petitioner. That is why, my lord, the retirement benefits was affected. But, my lord, the point was stuck on the issue that the provident fund dues of the petitioner.
Have you bothered to read the last order?
Yes, my lord.
What is the last order?
Affidavit has been prepared, my
So
lord.
say, tell us where you are filing it.
My lord, the
Why you
affidavit has been prepared, but the department has not affirmed it, my lord, because they were waiting for the provident fund dues to be paid, my lord. Now, my instructions are that they have been paid. They want to incorporate this point in the affidavit, my lord.
Give the affidavit. When will you file the affidavit?
My lord, this point has to be incorporated in the affidavit, my lord. It has been paid, my lord, only recently, my lord, on 10th of July. My lord, let us incorporate this point, my lord. Kindly gives us 1 week time. We'll incorporate this point in the affidavit.
As paid the
But
time.
you will submit the status report. And
1 week
also
time
entry.
But I am for the respondent. My last occasion, my lord, direct us to take instruction for the department. What is the present position of the appeal pending before the? Now they send instruction, my lord, can receive. The first page, last but one paragraph, the first page. Last but one paragraph. First, since the petitioner retired from railway service, the full case file was sent to the competent authority, that is the President of India, with the proposal of recovery as a whole or part of the pecuniary loss caused by the Sri Alvar while he was in service, and also to cut pension arrangement. At present case, DA is proceeding is under the consideration of the President of India. Pending file is enter file is pending with President of India. So,
my lord, I am appearing for the petitioner, my lord. Now, my lord, here my learned senior friend is stating that the case file is pending before the president. However, the order which was punishment order which was imposed upon the petitioner was set aside by the appellate authority. And thereafter,
last instruction on
no, my lord.
You please give him a copy.
copy.
Yes, my lord, after in the report it is stated that disciplinary procedure.
The appellate authority had remitted it to the inquiring authority.
To the disciplinary authority from the stage of right from the beginning, because there are some irregularities.
So therefore it has to go before the inquiry officer.
Yes. Yes.
Fresh means before the inquiry officer.
Yes, but my lord, since 2022, my instructions are that nothing has happened.
No, but see, they say after receipt of thereafter a report has been received from the inquiry officer, and the petitioner has also filed his representation on 8/6/22. So this is about 1 month after the order passed by the appellate authority.
Is not within my knowledge. I sought specific instructions as per my lord's last order, that whether anything has happened since.
Find out, because they are saying so on in this report with a specific date that you pass the petitioner has filed his representation on 8/6/22. Is the representation here?
The representation, yes, it has been annexed. Yes, it has been annexed, my lord. My lord.
Yes.
Lord, I shall specifically show this to the petitioner.
Find out.
Yes, I shall find out. Only one submission, if my lord allows me.
Yes.
Is that the appellate authority said that there are certain irregularities, did not specify what the irregularity is in particular. The disciplinary authority or the railway authorities have decided or ascertained that since inquiry report was not submitted, that is the only irregularity. But in the memo of appeal, I should determine and come
the
back.
appellate authority has not specified the illegality.
No.
Where is that? Let us see.
Kindly comes to page 127, my lord. (128). I'm sorry, my lord. 128. This is the order passed by the appellate authority.
No, so it has not, but it says afresh. That means everything is gone.
Yes.
Whatever may be the illegality or irregularity, now it has to be done afresh.
Afresh. Now they have said that only the inquiry report was submitted and the defect pointed out by the appellate authority has been rectified.
Whatever it is, if the petitioner is participating there and now.
Yes, my lord, I shall inquire this. Otherwise,
this we have to know for sure whether he is.
Yes.
Because after 25/5/22, Inquiry report served on 26/5/22. Just the next day. One day after the appellate authority's order. F5 is F5.
My lord, one more thing, I do not wish to cast any aspersion.
Yes.
The only thing is that at page 127, in the memo of appeal which is annexed to the writ petition, I have signed my full name. But in the representation to the inquiry report, it is only a short signature. My lord,
We don't
I
think
will,
they will go to
yes,
this
no,
extent.
I am not suggesting, but I'll just make sure of this because it will be irresponsible to make such a outlandish submission. But I'll just go and inquire this. দিলাম আমাদেরকে দিলাম দেখি আমি এরকম সাইডে দিলাম আপনাকে এই যে,
He's not done it afresh. Disciplinary authority's order was challenged before the appellate authority.
Yes. Now, my lord, there is also no fresh order by the disciplinary authority. That is also.
Where is the disciplinary authority's order? What
My
was
disciplinary authority's order is at page.
found no infirmity?
My lord.
Did the disciplinary authority
No,
find?
disciplinary authority just plainly they said I have applied my mind, I have considered, and the petitioner is guilty. However, since he is retired, I cannot impose any punishment, but recovery of dues may be continued. Recovery of dues itself is a punishment. The order of the disciplinary authority
So what was the relief
is at page
you prayed
120.
for in the tribunal?
Quashing of the entire proceeding. Page 123 is the order passed by the disciplinary authority. Unreasoned order subject to correction, my lords. Just states that I have considered.
So the disciplinary authority has not passed any order on the representation till now.
Yes, that is one thing that is still left.
See, the way things have progressed, according to him, a corrigendum to the charge memo was issued after the hearing.
Yes.
He says that is not permissible. He has raised the issue, nothing was considered. He raised the issue before the appellate authority. Appellate authority said, all right, disciplinary authority will consider afresh.
Yes.
So now he has given all these facts before the disciplinary authority. On 8/6/22, till date, nothing has been done.
Yes, it is exactly what I was trying to point out to your lordships.
That has been sent to President of India for.
President of India disciplinary authority has to take a decision. It can't be unless.
Can you see the rules? Can you see the rules?
Sir, forget about rules. It is 3 years since he made his representation. We don't know where it is pending and why it is pending for 3 years. Can we countenance pendency for 3 years for an order to be passed by the disciplinary authority?
Then I shall take
He
instruction.
is a retired person. His dues are withheld for this. Just because you are dragging your feet in the matter, his dues are withheld.
It should be. But can we keep it next week? I shall take instruction. What is it?
Huh?
I shall take instruction next week.
What instruction you will take? Your instruction is up to date. There is nothing. You are doing nothing.
Why this? No, after retirement, proceedings can be done. Manokani rule.
Who is saying no can't be done? Who has said? Is he saying can't be done? Rule 9 of his service rule, he knows. He is serving.
Yes, rule 21. That's it.
So it can be done, but is to be done in this way. After the appellate authority's order, you are sitting over it for 3 years. You place this on record by affidavit. You file it. The learned advocate appear.
Number 104. 12 August.
না আমি অ্যাডভোকেট রেকর্ড নাম
not to report.
My lord, Mr. Toro, the learned senior advocate, is appearing in this matter. My lord, he's on his legs. My lord, I'm seeing a short passover. My lord, Mr. Toro, the learned senior advocate. My lord. My lord, I'm not briefed in this matter. My lord, I'm just under instructions to see the passover. My lord.
না আমি ওই বলছি not today করে না আমরা অন্য জায়গায় করি
So he says anytime.
Let it start. Communication. अरे नॉट टुडे করতে জয় করিয়ে না পাঁচ ওভার বলছো নট টুডে
ধরে না আমার অপরাধ পড়ে যাচ্ছে
এই জন্য বলছো আরে আমি আসছি
but I'm being told that he's coming, my lord. It's not.
Yes, Your Lordship.
The memo containing the MCAS scheme, 2011. What we gather from the tribunal's order is there are three benefits. One on conclusion of 8 years, other on 16, and third on 25. The 25th year benefit he wants, which has been denied. Two reasons you have stated in the
Affidavit.
before the tribunal. One of them is that since that was due to him in 11, since the scheme came in 11, he was not entitled to get it. No, the scheme is of 2012, 28/12/2012. So it had no retrospective effect. That was one of the stand taken by. So where is the scheme of 28/12/2012? One of the stand is that because he was promoted in the higher statistical service, you say one promotion he has got. Other is that there is no retrospectivity. These are the two grounds urged by. This 2012 scheme, where is it? At least I will get an opportunity.
180, 180.
One?
180.
One 181.
180, 12. 181. 180, start with 12. 181 is a typed copy.
Oh. Original is at 180.
4, Your Lordship. This order will take effect from 1/12/2012.
Where is the MCAS scheme?
Scheme.
Yes, Milord. Milord, I mean, very tender my apology,
No,
Milord.
no, please, you are waiting.
Yes, Milord. Milord, before coming to the judgment, Milord, I precise the state of facts, Milord, leading to prefer this application before your Lordship, Milord. That the petitioners, Milord, in the year 2001, initially joined as a district statistician, Milord. District statistician officers and not as a statistician, assistant statistician, Milord. In 1981, Milord. Then the petitioner's post of district statistical officer, Milord, was confirmed, Milord, from 1/1/1986. Then thereafter, petitioner was promoted as assistant director in 1988, Milord. Then, Milord, after completion of 10 years of service, Milord, pursuant to the requirements of the modified career advancement scheme, Milord, that the petitioner's first benefit was extended, Milord. And in, Milord, 2001, Milord, the petitioner's, Milord, was extended the benefit of second, Milord, MSc benefit, that is modified career advancement scheme, after completions of 16 years, Milord. Then, Milord, in 2012, Milord, a notification was issued by the government of West Bengal. In the notifications, it was specifically pointed out that the person incumbent who is in grade 18 scale of pay, Milord, they should be extended the benefit, Milord, benefit of 25 years after completions of 25 years service, Milord. So this benefit, though the petitioners, Milord, after the issuance of this notifications, Milord, retired, Milord, because the notifications was issued on 12 December 2000, 12 December 2000, 12 December 2012, Milord, and Milord, the petitioners retired, Milord, on 13 July, Milord, 2013, Milord. So therefore, Milord, after coming into force of the notification, Milord, the petitioners has retired, Milord, and therefore, Milord, the petitioners is entitled to get the benefit of that scheme, Milord. And this was admitted fact, Milord, that was found by the various officers in their communications. Then, Milord, I'll take your Lordships, Milord, to certain documents, Milord. First, Milord, I invite your Lordships' attention, Milord. at page 106, my lord. First 104. First volume, my lord.
When did you complete 25 years?
Yes, my lord. 25 years, my lord. On 13th July, my lord. 20 years ago, complete করেছি?
On 1st June 2011.
On 1st June 2011, my lord. And the notifications, my lord, I invite your lordship's attentions at page 181, my lord. At page 181.
After you were promoted as a director in 89.
Yes, my lord.
Did you get any other promotion?
No, my lord.
That is the only promotion you
Yes,
have
yes.
got.
Post was upgraded, my lord. So, my lord, I invite you.
When was the post upgraded?
Upgraded, my lord. Upgradation took place, my lord. Yes. First promotion, my lord, on 4th June 1988, my lord. 4th June 1988. On the recommendations of the PSC, the petitioners was promoted to the cadre of West Bengal Statistical Service and posted as Assistant Director and Statistician on the scale of pay of rupees 22,000 to 4,000.
Assistant Director in which year? 88. 1st June.
1st June, my lord.
And second promotion as Director in 89.
Yes, my lord. On second promotion, my lord, 1995. 9th November 1995.
No, you said
at page 124.
You said Director in 89. At the very outset, you said he joined in 81, confirmed in 86, and promoted as Director in 89.
No, 80.
This is the dates you gave us at the very outset.
1 minute, my lord. No, 86.
Confirmed in 86, Director in 89, joined in 81. These are the three dates you gave us.
No, my lord. Promoted on, my lord, 1995, lord.
So let us, just a minute. Joined in 81 is, there is no dispute?
Yes.
Confirmed on 1186 is
yes,
okay?
My lord. This is correct, my lord.
Then what comes?
Then, my lord, on 9th November 1995.
Yes.
My lord, on careful considerations, I am reading out, my lord, the order, my lord.
No. Before that, in 88, you have got a promotion as Assistant Director. Now you are skipping that.
Yes, my lord. 1988.
See, the issue is whether you have got 3 promotions or not.
Yes.
That is one of the issues. Therefore, we are asking you, give us the relevant.
Yes, my lord. First, my lord, in 1998, my lord, at page 159.
98?
1998, my lord. 1988. The recommendations of...
Please get your dates right.
This is
not be 98.
Pay Commission, 17 post of District Statistical Officer. Oh, yes, my lord. Now I'm clear, my lord. My lord, petitioner joined in 1981, my lord. He was confirmed on 1986, my lord. In 1988, my lord, on the recommendations of the PSC, my lord, the petitioners was promoted to the cadre of West Bengal Statistical Service and posted as Assistant Director and or Statistician on the scale of pay rupees 2,200 to 4,000. And 9th November 1995, as per recommendations of Third Pay Commission, being the West Bengal Service ROPA Rule 1990, 17th post of District Statistical Officer belonging to the West Bengal Statistical Service was upgraded and included in the cadre of West Bengal Statistical Service in the post of Assistant Director.
So how this is relevant? This is not relevant for you. You
No.
already joined the West Bengal Statistical Service as Assistant Director in 88.
Yes, 1981. Then
88.
First, yeah, 88. And first benefit, Milord, I got, Milord, in 1998. After completion of 10 years, Milord.
Sir, you gave us a date that you joined in 81. Then you said you were confirmed
yes.
as District Statistical Officer in 86. Then you said you were promoted with recommendation of the PSC in 88 as Assistant Director in the
Yes,
West
Milord.
Bengal Statistical Services.
Yes.
So then what is the relevance of this upgradation of a statistical officer? That is meaningless for you. You have already become an Assistant Director in 88.
No, that was upgraded, Milord. No promotion.
But you said in 88 after PSC's recommendation you were promoted.
In 88 the promotions was given, Milord.
Yes.
Then 10 years was complete, Milord, was completed, Milord. In Milord. No, from 1986, Milord, to 1996, Milord, and the first benefit was given in 1988, Milord. That, Milord, I invite your Lordship's attention, says page 159. That is the first benefit, Milord. Sri Amit Gupta has joined in the West Bengal services on 24th January 1981. Thereafter, he has been promoted in the West Bengal Statistical Section on 7 June 1988. In terms of Finance Department memo number 9th January 1995, post of District Statistical Officer belonging to West Bengal Director Statistical Service have been upgraded and designated as Assistant Director. The upgradations had been allowed to all the officers of West Bengal Junior Statistical Service on the basis of their seniority with effect from 1/1/86. Consequently, Sri Gupta has been allowed to enjoy the benefit of revised pay scale of Assistant Director in the scale of rupees 2,200 to 4,000 with effect from 1/1/86. Thus, he has exploited 10 years of continuous service on 1/1/96 in the said scale. Accordingly, Sri Gupta is allowed in terms of para 215 of Finance Department memo to move from the existing pay scale of 2,200 to 4,000 to the next third scale of pay 3,000 to 4,460. Then, Milord, I'll take you, Milord, your Lordship, Milord, 169, Milord, page 169. Typed copy at page 170. At page 170. The following officers joined in the post of West Bengal Junior Statistical Service under Directorate Office of BKES West Bengal, administratively controlled by Development of Planning Department, Government of West Bengal. The scale of pay of rupees 400 to 750 under ROPA 81. Herein dates of joining of West Bengal Junior Statistical Service. The date of confirmation are shown against their name. In terms of Finance Department memo number so and so dated 9th November 1995, 17 posts of District Statistical Officers belong to West Bengal Junior Statistical Service had been upgraded and redesignated as Assistant Director in the cadre of West Bengal Statistical Service in the scale of pay rupees 2,200 to 4,000. Made ROPA rules 1998. The date of upgradation in respect of these 6 officers are also shown against their names in terms of this department so and so dated 19th October 2005. These 6 officers and BAE and S West Bengal had been upgraded and appointed in WBSS as direct recruitment with effect from the dates of upgradations as shown herein. In pursuant to promotion policy of the Government of West Bengal, the officers listed herein 1 to 3 and by virtue of career advancement scheme benefit after completion of 10 years satisfactorily service, officers are listed herein at serial number 4 to serial number 6 were appointed in the scale of pay of rupees 3,000 to 4,750 under ROPA 98 with effect from dates shown against their name against the officers listed at serial number and serial number 2 were promoted to the post of deputy director in the same scale of pay, and both of them joined in the same post with effect from 1st January 1999. All these 6 officers have completed 16 years continuous satisfactory service. Hence, these officers are hereby allowed the benefit of career advancement scheme with effect from date shown as the date of entitlement to career advancement scheme against their names in the last column, my lord. The next page, my lord. Amit Gupta's appeared that the name, my lord, find place of the petitioner, serial number 3, my lord. Amit Kumar Gupta. Date of joining, 21st January 1981. Date of confirmation, 1st January 1986. Date of upgradations and entry, the scale of pay rupees 8,000 to 13,000. That is 1st January 1986. Date of entry in the scale of pay rupees 10,000 to 15,500, 1196. Date of entitlement.
So
to career-
second CS benefit you have
So
got
two,
in.
my lord. Two benefit we have got,
Yes.
my lord.
Now-
But the third benefit has not been given, my lord. And against which, my lord, ultimately we moved an application
Third
before
would
the
be due to you in 2011.
11, my lord.
Now after 2002,
Yes.
after this order was issued, granting you benefit with effect from 2002.
Yes.
Did you receive any further promotion?
No.
2007 notional.
Yes, in 2007 notional promotion.
Because
Huh?
In 2007 notional promotions was given.
Because the pay benefits are already.
Where is that order?
Yes, my lord. One minute. Page.
Page 170.
Yes, my lord. Page 179. পড়া যাচ্ছে না ভাই, page 1. The government is pleased to appoint the marginally noted officers Sri Amit Gupta, Deputy Director, Headquarter, Kolkata 1, by Srimati Swanso, belonging to West Bengal Statistical Service on promotion to West Bengal Higher Statistical Service of Bureau of Applied Economics and Statistics, West Bengal, and to post them as shown herein against their names with effect from the date of their joining and until further orders. The order is issued in the interest of the public service.
Page 180 to 181. এখানে তো নোটিফিকেশনের ফুল রিকোয়ারমেন্ট 25 বছর 3 বছর।
না, উনি যেটা দেখতে চাইছেন যে ওই 7-এর আপগ্রেডেশনটা, 7-এর আপগ্রেডেশন এক 7-এর আপগ্রেডেশন P8টা দেখো, P8 171.
So this is a promotion granted to you on February 2007.
Yes, my lord.
So this is in between 8 and 16 years.
Yes.
Sorry, 16 and 25 years.
25 years.
So then how can you get the benefit once you have got a promotion in between? Can you get both?
No, my lord. I once again I invite your lordship's attention, my lord, to the requirements of the notifications at page 181.
No,
The
no,
question-
that is not the scheme.
Yes.
The scheme, we have not seen it, but based on your submission, what we could gather is one stagnation benefit
Yes.
after 8 years. Second is stagnation benefit after 16.
Yes.
Third is stagnation benefit after 25.
Yes.
Now stagnation benefit can be granted if you stagnate.
Yes.
If you have been granted a promotion between 16 and 25 years by this notification of 9/2/2007.
28/12/2012.
Huh?
28th December 2012, the notifications came into force, my lord, with effect from 1st December 2012. Requirements is that, my lord, that the persons, my lord, incumbent who has held the post of scale of pay, my lord, in scale number 18, my lord, for 3 years, my lord, he is entitled to get this benefit if he's completed 25 years of service.
So you are not claiming the benefit of CAS scheme.
No, under this scheme, we are getting this benefit.
Where is that?
Yes, that is at page 181.
That is not at page 181. We want to see the CAS scheme.
Yes, my lord. After
that is some notification for people who are being paid the 1800 scheme, scale.
Yes, my lord.
That is of 2012.
So
that has come into effect in 2012. See the clause 4 of that document.
This order will effect from 1st December to
2012, not before that. Cannot be. There is no retrospectivity attached and it cannot be in a notification.
No, this order will take effect from 1st December.
Correct. So it cannot take effect from prior thereto.
No,
the natural corollary is it cannot take effect from prior thereto.
Milord, I retired, Milord. I retired on Milord.
You retired in 13.
July 2013.
13 you
after the issuance of this notification.
Correct. So it has to be read with the CS scheme. Or it has to be read in isolation. You tell us.
No, Milord, that Milord, possibly, Milord, because the department also came to a findings, Milord, that I'm entitled to get this benefit.
Where is that finding?
Yes.
Where is that finding?
Yes, Milord. I invite your Lord, Milord. ওই যেটা ওই ডিপার্টমেন্ট যেটা ইয়ে করেছে টোটাল ইয়েটা ফাইন্ডিংসটা yes at page yes milord at page 256 milord notes and orders milord.
This is the CAS scheme.
Yes, milord. Service history, milord. Sri Gupta is as follows. Sri Gupta joined the government service on
You are reading page 256.
Yes, milord. 256, milord.
Oh, no, this is a file noting. This doesn't
yes,
mean
milord,
anything.
the file noting, milord, they categorically admitted that the petitioners completed 25 years and entitled to get this benefit. Yes.
This is not the time, please.
I'm not mentioning anything.
Sorry.
Not the advocate appealing is English first. We have to come. Your lordship, please to discuss.
Yes. Not now. Yes, please proceed.
104, continuing matter.
Yes, my lord. Now, my lord, I have streamlined the fact, my lord, so I will not give you trouble to your lordship, my lord. First, we'll take your lordship, my lord, at page 106, my lord. That is the first appointment in 1981.
Yes.
Page 106. Then, my lord, my confirmations, 104. Then confirmation 106 from 1986. Then, my lord, I'll take your lordship, my lord. Yes, my lord, at page 108, my lord.
No, we need not go into all of that. See, what you have argued by now is you joined in 81, 24/1/81. You were a district statistical officer confirmed on 1/1/86.
Right.
You came to the West Bengal Statistical Service as assistant director in 88.
Yes.
There was some decision in 95 that all the district statistical officers have become assistant director. So as a benefit of that decision, you also became assistant director with effect from 86.
Yes.
This is what you have told us.
Yes. Yes.
Then you were showing us this note sheet.
Then, my lord, then I'll take your lordship, my lord. Then I'll take your lordship to page 124, my lord. Paragraph 2, my lord. If in careful considerations of the recommendations of the peer review committee, the petitioners has been pleased to order that in respect of the post mentioned in column 2 of annexure, the revised scale of pay under the provisions of the West Bengal Service ROPA Rules 1990 shall be as shown in column 3 of the annexure in partial modifications of the notification number so and so dated 12/1/1990. I'll suppose for a moment, my lord, I'll take your lordship, my lord, to the notification at page 112, my lord. My lord, paragraph 3.
Under paragraph 5, subparagraph 3, under paragraph.
Yes, my lord.
What are you claiming, sir? Let us be clear first.
Yes.
What are you claiming?
I am claiming the benefit, my lord, after completion of 25 years service, my lord.
Are you sure?
Yes, my lord.
So, for that only one thing is relevant.
Yes.
Whether you have got 3 promotions or not.
Yeah, exactly.
So,
exactly.
Why we are not required to see all these
Yes,
documents?
I have got 2 promotions. You know, then state to my lord, I'll take you, my lord, to that 3, my lord. 3
Yes.
document, my lord. Yes, my lord. Then, my lord, I'll take your lordship, my lord, to page 129. Ten years টা কোথায় গেল? Oh, 124. One minute. Yes, at page 159. Consequently, Sri Gupta has been allowed to enjoy the benefit of revised pay scale of assistant director in the scale of rupees 2,200 to 4,000 with effect from 1186. Thus has exploited 10 years of continuous service on 1196 in the said scale. So first Milord in Milord 1996 Milord. Then I'll take your lordship's Milord to page 179 Milord. That is the second promotion, Milord. Sri Amit Gupta. Place of posting on at page
79 or 169?
179.
Yes.
That is the second promotion. Sri Amit Gupta or the last promotion. Place of posting on promotion, Deputy Director. So belonging to West Bengal Statistical Service on promotion to West Bengal Higher Statistical Service of Bureau of Applied Economics and Statistics, West Bengal, and to post them as shown hereinafter against their names. So this is the second promotion, Milord. Though this promotion order was issued on 19th February 2007, Milord, but on 25th February, I will take your lordships at page 170. On 22nd May 2007, because this was passed on 19th February 2007, then Milord, I'll take your lordships at page 117, 170. On 22nd May 2007, Milord, the benefit, Milord, having been completed of 16 years of service, Milord, that was extended to the petitioners with effect from 1/1/2002. That is all 6 officers at page 170, last paragraph. Yes, 1 minute.
When did you complete 8 years?
All this, yes.
When did you complete 8 years?
No. 10 plus 16, not first benefit.
When did you complete 8 years?
10 years.
When did you complete 8 years?
10 years in 96, Milord.
8 years in 94. What is the relevance of 10
Milord,
years?
8
10 years has no relevance.
8 years in 1994.
8 years in 94.
Yes. Where the scheme says, Milord, 10 years and 16 years. And 25 years.
Where is the scheme?
Yes, Milord, at page 181.
That is not the scheme, sir. 181 is a memorandum issued. We are asking where is the CAS scheme? We have been asking you since before recess. Where is the CAS scheme?
Yes, Milord, because that was not disclosed here, Milord. What happened, Milord? Because 10 and 16, Milord, that was admitted, Milord. So
not
therefore,
admitted. Before lunch, you were saying 8, 16, 25. Now you are saying 10, 16.
No, Milord, sir. I always said, Milord, 10, 16, 25.
Please show us the scheme. Whatever you may say is not relevant.
Then if your lordship so desire, Milord, because since, Milord, this is not in dispute, Milord, so that's why we have
It
not
is,
disclosed.
from what we have gathered, they have said 8, 16 and 25. You were also saying 8, 16, 25, but post lunch you are saying 10, 16 and
Milord,
25.
all through we have made out a case, Milord, 10 years, 16 years, and Milord, 25 years. And they have admitted in their note sheets and all the communications also, Milord.
Note sheet means nothing.
No, Milord, even in the order, Milord, even certain communications they admitted that I have completed 25 years of service.
Where is the dispute on 25 years? Who is saying you have not completed 25 years? We are asking you, there is a scheme. You are claiming a third progression under the scheme.
Because third progressions, because that should be implemented on the basis of this notification.
Where is the scheme on which you are relying? We are asking you since pre-lunch session. Where is the scheme? Let us see what is the requirement.
Milord, so far that scheme is concerned, I'll Milord, definitely I'll produce, Milord, before your lordship, Milord, by way of a supplementary affidavit.
Why supplementary affidavit? It must be in some book or somewhere. This scheme is being.
As such, but we can find out, we can get the notification.
It's
on
not,
the-
it's not in any publication.
These are notifications, Your Lordship. Like on the earlier occasion, we produced the notifications regarding the compassionate.
What is the, please tell us the three progressions are due after how much service?
10, 25. In the event of stagnation.
Obviously, all these schemes are to overcome the stagnation, yes.
There are prerequisite conditions also in this scheme.
So the normal conditions for promotion have to be fulfilled. This is the requirement under the scheme.
Conditions are. Your Lordship, I have to come back with the CAS.
No, if there is no dispute on this, then we can proceed.
Yes, my lord.
So it is 10, 16, 25.
16 and 25.
And the other thing is that the normal requirement of promotion has to be fulfilled by the person who is claiming the benefit.
No, because I have completed only 10 and 16 I was given. Because 25, my lord, after completion of 25 years, that benefit was not extended to me, my lord. That is my grievance, my lord.
What we ask you, please first respond to that, then we'll hear your grievance.
Yes, my lord.
We said there are two things she is submitting, 10, 16, 25.
Yes.
Other things she is submitting is that the normal requirement of promotion you are required to fulfill before you get the benefit of CAS scheme. So this is not in dispute.
Big.
That is 1990.
I don't know what is the problem. What are we speaking? We are speaking plain and simple English. We are asking you that apart from the time, a person is also required to possess the qualification for promotion. Is there a dispute
Yes,
on
my
this?
lord. So far, the two promotions is concerned, there was no dispute. 10 years, 16 years, my lord. But after completion of 25 years, that was not extended, my lord. That is the case. And to get the benefit, my lord. And only requirement, my lord, to get the benefit, my lord.
For the fourth time, we are asking you.
Yes, my lord.
Apart from completion of time for benefit of CAS, is there a requirement that the person who is claiming the benefit is required to fulfill all the qualifications for a regular promotion?
No, that is not.
That's not there.
That's not. 1 minute. That's not.
May I come back with the notifications, Your Lordship?
Then there is a dispute. There is a dispute.
There is a dispute.
Because they have specifically said that even otherwise you are required to possess the requisite qualification for a normal promotion.
Yes.
Apart from the fact that you are stagnating, both things are required.
Yes, this is their contention that I did not fulfill the requirements as contained in notification dated 28 December 2012. So that's their
That
contention.
is not a CAS scheme, sir. That is a different thing. That is a pay revision scheme that you are relying upon.
No, my lord, then
please read the 2012 one.
The question of 1 minute. The question of, my lord, movement to pre-device scale 19 for the officers belonging to the State Statistical Service other than West Bengal State Secretariat Service has been under the considerations of the government for some time past. After careful considerations of the matter, the governor has been pleased to decide in above to move the officers belong to West Bengal State Constituted Service, then West Bengal Secretariat Service, home in scale number 10 to move to pre-revised scale number 19.
That is a revision. That is not a CAS benefit.
As per ROPA, after completion of 25 years of service.
That may be 25, but this is a revision. This is the effect of a revision.
That revisional benefit I have not been extended.
So say that you are saying CAS benefit. You are claiming a revisional benefit.
My lord, otherwise, if yes, my lord, if it could be termed as a, my lord, divisional.
It has
benefit.
to be a revisional benefit.
Yes,
it can't be a CAS benefit.
Yes, lord. I bow down your lordship's observation. My lord, then
that is why we have been
yes, my lord. So therefore,
asking you repeatedly.
So therefore, my lord, pursuant to this notification, I'm grateful to your lordship, my lord. Pursuant to these notifications, my lord, two things are required. One has to complete
completion of 25 years and the
3
second
years
is
in the post scale number 19.
That is all.
That
this
is
all the requirement.
And I have fulfilled all this requirement. Then
not scale number 19, scale number 18.
Yes, scale number 18. Scale number 18. Yes, my lord. Scale number 18.
Yes, scale number 18.
Then I'll take your lordship's, my lord, to 179. That is my last promotion.
So how do we know what is your scale? Which scale number you are getting? From where can we gather this fact that you are getting scale number 18?
That I will get, my lord, at page 170. So promotions were page 170. Last paragraph, my lord. All these 6 officers have completed 16 years continuous satisfactory services. Hence, these 6 officers are hereby allowed the benefit of CS scheme with effect from date shown as the date of entitlement to CS scheme against their names in the last column. Then Amit Kumar Gupta is appearing serial number 3, my lord. First, second, third, fourth. Amit Kumar Gupta, date of joining 21st January 1981, date of confirmation 1/1/1986, date of upgradation 1/1/86, date of entry in the scale of pay of rupees 10,000 to 15,525, 1/1/96.
Where does this say that you are getting scale number 18?
Scale number 18, it was not mentioned, but the higher scale.
We asked you from where you are saying you got scale number 18. Now you are reading this document which says nothing about scale number 18.
Scale number. Because
hundreds of pages, 3 volumes. There is only 2 things which are required to be seen. Whether you complete 25 years, whether you have 18 number scale. You are not able to show these 2 things.
This 12,000 to 18,000, my lord, this scale of pay, my lord, is under 18, my lord. But, my lord.
Which one?
That this is, my lord, that the officers of E&SB are hereby allowed.
1200 to 1800, 12,000 to 18,000 is serial 18.
Yes, my lord.
From where can we get this?
That, my lord, I didn't find, my lord, anywhere, my lord.
But you have to tell us. That is the whole basis of your entitlement.
Then
you can't find it, then how will we pass any order? Then you are not entitled.
One minute, my lord. Millers, in the note sheet, Millard, they have also proceeded on the basis that this is Millers in the scale number 18, Millard. If I read out, Millard, that Millard, at page 257, Millard, it starts from 256. The entire Millard gamut of the case has been narrated in the note sheet. That's why, Millard,
Can anyone derive any right from a note sheet?
No, my lord, that is right, my lord.
Sir, that is why we are asking you show from some where is your averment in the OA?
On the basis of note sheet, my lord, the petitions was asked, my lord, to submit a few documents to extend
Very
this
well,
benefit.
if that is all you are relying on, then we'll consider whether the note sheet can be considered.
I invite your lordship's attention at page 274A, my lord. The undersigned is directed to refer to the above and to request him to submit the following documents in connections with allowing MCS benefit of 25 years of service in respect of Sri Gupta. Last 3 years ACRs, statement on up-to-date asset declarations, integrity clearance. Nothing else, my lord.
See, this is regarding your MCAS benefit, and that is the revisional benefit. There are 2 things. One is a MCAS after completion of the between 16 to 25 years.
Yes.
Other is benefit of that memorandum that you read of 2012, which says the moment a person is at serial number 18 pay scale for 3 years, he will get this revisional benefit. Now, when we ask you about the revisional benefit, you are showing us MCS. How these two can be reconciled?
I understand your lordship.
You understand, but we are trying to understand. We are unable to.
Yes, my lord. I'm praying for, my lord, at least 1 week time, my lord. Then I'll come back and satisfy your lordship. I'm quite sure, my lord, that is scale number 18. And on the basis of that, everybody has proceeded.
Where is your OA? Let's see whether you have said in your OA that you are
Yes.
getting scale number 18.
Achha. Where is scale number 18?
There was an amendment.
তাহলে রুলসটা দেখাও, তুমি এখান থেকে খোলো। এইটাই তো স্কেল নাম্বারটা, কোথাও তুমি তো কোথাও তো বলনি।
219.
290 that I have got, but কেন তুমি বলনি?
Here.
কোথাও কোথাও হ্যাঁ And at page 318, one of the ground was taken, my lord. That scale 19 was not given, though similarly circumstance junior was extended this benefit. 316.
306.
In the way, my lord, it was stated, my lord, at page 306, my lord, paragraph 10. But still scale has not been, my lord, identified.
Scale 4B.
সেটা কোথায় পাবে যে 4B?
Please read the second paragraph at page 301. According to this, you have made an assertion that you were already in scale number 19. Please read the second paragraph at page 301 in your OA.
Wait, 301.
Yes, paragraph R.
Such movement will purely non-functional. On 28 December, the Finance Department, Government of West Bengal issued another memorandum number so and so.
You are
It was
reading page
decided-
12 of the OA.
Yes, my lord. At page 300, my lord.
The applicant retired as a deputy director. Second paragraph.
301. Yes. R. retired as the Deputy Director, Industrial Secretariat Office, Bureau of Applied Economics and Statistics, Government of West Bengal, which is in the cadre of West Bengal Higher Secretariat Service on attaining the age of superannuation on 31st July 2013. That is after coming into effect of the modified career advancement scheme on 28 December 2012, under which his service was moved from service born in scale number 16 to pre-revised scale number 19.
So you say from 16 to 19 you have already been,
as well as the cabinet decision dated.
So if you are already in a scale number 19, where is the question of getting a benefit available to scale number 18? That is your assertion in the OA.
Under which his service was moved.
You say already moved under the assured career progression scheme from 16 to 19. And then you say that by virtue of being in the serial number 18, you are entitled to a benefit. We don't know. That is your client's assertion in the OA.
It's not the, Lord, I'm very sorry, it is not the correct state of fact, my lord.
Your client's statement is not correct.
Yes, Lord, it is. But the scale of pay which
slightly
was,
difficult to,
yes, Lord, scale of pay which was extended to the petitioners, my lord, at page 179, my lord, that is scale number 18, my lord.
We don't know. You are just saying that.
That I will satisfy you.
That is not there anywhere. You are saying it
No,
is
that-
scale number 18.
no, that
Your client has not said it. We
Yes,
don't know
yes.
how you can see it.
Yes, my lord, that I will satisfy, my lord. But sometimes, my lord, if
In fact, your client says he has already traveled from 16 to 19.
no, my lord, it can't be, my lord. Because this benefit was extended, my lord, only, my lord, in respect of scale number 19, and he is entitled. Because still he held the post, my lord, in scale number 18, which would be apparent from page 179. So, well, 1 week time maybe give him, my lord.
As played list on 28 July.
Thank you. I'm grateful to your lordship. Yes, good record. Yes. Hey, it's a basic requirement.
105.
Basic requirement. I'm grateful to your lordship.
My lord, 105, I am for the respondent, and 106, I am for the petitioner. My lord, this matter relates to pay fixation. My lord, I am praying for a week's time, my lord. Can it be kept next week, Tuesday, 22nd?
What is your difficulty?
My lord, my difficulty is actually the pay fixation, because there is a
Fixation has to be adjourned.
no, my lord. The issue in this pay fixation, there is a the issue needs to be addressed. I have engaged, my lord, a senior advocate, and he's engaged in another.
As played list after 1 week.
One 106.
22nd.
22nd. Grateful.
107.
107, I am for the malad petition.
Page 535. Page 56.
And for the petitioner, my lord. My lord, petitioner was, my lord, selected for lower division clerk, my lord.
For
lower divisional clerk,
LDC
under the government of West Bengal, Department of Food and Supplies. My lord,
in 2009.
2009. Now, my lord, what happened? Petitioner was falsely implicated in a criminal case under section, my lord, 498.
his daughter-in-law, that is my lord, wife of the elder brother, lodged a complaint against the elder brother and their family members, and my lord, he was implicated in a criminal case, my lord. Now, my lord, petitioner, since my lord, petitioner after selection got no appointment letter, at such my lord, petitioner moved a writ application before this, my lord.
What is the date of the police case?
My lord,
Police case is of prior to your appointment or subsequent to you?
prior to my appointment. Yes.
So it is a case of not mentioning in the verification roll. I thought so.
My lord, verification roll was NA was subscribed, my lord, in respect of verification loan. That there no case was.
What is that judgment?
Lord's
Tax court judgment. Avatar Singh.
After Avatar Singh, my lord, there was a further judgment, my lord.
Yes, then show us, please. That will be very
That
nice.
judgment, my lord, Pawan Kumar.
Avatar Singh has been considered.
Considered, my lord. After
Let's
considering the same, they had to copy this judgment was passed, my lord. Another thing is this, my lord. The petitioner was declared as unsuitable by rejecting his appointment, that unsuitable. But nowhere, my lord, it was stated that since he was suppressed the facts, that is NA, written in the verification roll, that is why he was unsuitable. Only in the reply filed by the respondent authorities before the tribunal, it was noted that the reason for such rejection, my lord.
Obviously, you are not a confirmed employee, so they are not required to either
Now,
conduct.
my lord, since my lord, my respectful submission.
Only thing is whether this suppression can entail such consequences. Therefore, we asked you whether judgment of Avatar.
Lordships.
You say it has been reconsidered. We are looking into it.
কপিটা দুটো ছিল রে, আরেকটা লিঙ্ক বলে দিয়েছি। পরে নিচ্ছি, শেষ পথে আছি। Here, my lord, case regarding, my lord, gravity of the criminal case was considered. There's a very.
Just we are reading. Just give us 2 minutes. Yes. Here, the criminal case was after the application. The judgment you are relying upon, the criminal case was after the application. Therefore, there is no question of suppression. In your case, criminal case is of 2002.
But regarding my lord, submission of the my lord, police application before the authorities for scrutiny, my lord, the same was suppressed, my lord. That was the point was taken into consideration. And my lord, in this case also, my lord, kindly see, my lord, case was initiated after
the application.
That's
In
true,
the
my lord.
case that you are relying upon.
But my lord, the application which was submitted by the petitioner here in my lord for verification, in the said verification application, he was suppressed the material facts regarding criminal case, my lord. That was considered, my lord.
At the time of attestation, he did not disclose because he said that already the complainant had filed a affidavit saying that he will not pursue the matter. So therefore, he did not disclose.
Here, my lord, here,
court
my lord, that is not that is why he was acquitted. Here, in this case also, my lord, petitioner was acquitted from the criminal case. Very.
He was acquitted, but whether in this case also the complainant or informant had stated by an affidavit that we are not going to pursue with this matter.
My lord, here, my lord,
Because
petitioner
the
has
fact, the Avtar Singh judgment has not been in any way distinguished. It has been followed.
Followed, my lord, the
Singh
Avtar Singh also, my lord, this is the opinion of the Honorable Apex Court that each and every case cannot be taken into consideration as a state jacket formula.
Correct.
That, my lord, here, my lord, also, my lord, petitioner filed an application before the my lord, tribunal prior to acquittal, my lord. Prior to acquittal, he filed a application, original application before the tribunal, stating therein that he was implicated in a criminal case. And in the said judgment, the said matter was disposed of by the Honorable Tribunal, that after acquittal, he can file, his right will be adjudicated, my lord. That was the order, my lord. Kindly come to the my lord, order, my lord, page 67, annex, my lord. Order was annexed, my lord. This was the one in the year 2011. He filed this application, my lord. Page 65, my lord. Onward, my lord. Now, my lord, there were prior to rejection, sir.
What is the punishment for 498A?
3 years imprisonment, my lord.
3 years.
Well, acquitted, my lord.
What is the punishment?
3 years.
3 years.
3 years.
But in the police verification role is a very important thing.
Yes.
Well, prior to their decision, prior to their decision, lots of.
Yes. Yes.
Questions are whether arrested or in criminal case is pending. He said no.
Oh, he was arrested also.
Arrested, got a bail.
Released on bail, my lord.
Released on bail.
Next day.
Released on bail when? That means he has been arrested.
Next day, my lord. On next day, he released on bail, my lord.
That's not the point. That means you were knowing about it.
My lord, I am not my lord, prior to their decision.
This is the verification role.
Verification role.
Page?
103, start. Page 104 is the 102, column number 13. He was being arrested or detained by court of answer is yes. Particulars of the arrest conviction is appeal. Give me a cross. Suppression of act. After it will apply.
Is there any appeal pending?
No, my lord. No appeal was deferred.
Have you said so that there is no appeal?
My lord, question of appeal is no, my lord. That was copy of the order, my lord. I have annexed, my lord, order.
No, we are asking you whether any appeal was filed or
No, no, my lord. No, there is no appeal, my lord. If your lordship, no notice was served, my lord, regarding appeal till date, my lord.
Don't say that in spite of knowing you have suppressed. So therefore, notice served or not served, we don't know. But just we want to know whether appeal is pending.
No, 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 my lord. No appeal was pending.
34 of the Indian Penal Code was also there.
Huh?
Section 34 of the Indian Penal Code was also there. What 498A? A crime against the society. Objection reasons, kindly see the objection reasons in the parliament. 498 when was introduced.
No.
What is your instruction?
No, my lord. No appeal.
Crime against a woman.
My lord, acquittal was given by.
That is why we are asking whether appeal is pending or not pending. If not pending, then what is to be done? He's got an employment. The case has been already his acquittal has been recorded. Such circumstance has been taken note of in this judgment. But you state this fact on affidavit.
Yes.
That there is no pending appeal.
Great confidence. Within, my lord, 2 days, my lord. 2 days be allowed. Let it be taken up on next Monday.
We have to copy. Oh, you want to change?
108. Your Lordship, I am appearing for the petitioner on behalf of my learned senior, Your Lordship. Only not today, Your Lordship, I am praying.
Not today. Yes, we have seen the order. Whether he has got from the erstwhile employee, we now remember. Yes, Colin. Who has filed affidavit?
They have filed affidavit.
Today?
But I have received a copy, Lord.
When?
I have received, Lord, this is the date, 13th of May, 2025.
You still need time for reply. After 2 months.
Since the matter was appearing in the list and it didn't reach me, and direction to file
A direction is required for filing a reply. It has been served, you could have filed. For 2 months, you are holding on to it.
order, because it stated that to file specific affidavit.
Yes.
Affidavit is filed. So, there are various allegations made. Therefore, the reply is required.
What allegation has been made?
Yes,
Have you filed it?
No, Your Lordship.
Why have you not filed it? You have served them a copy and you have not filed.
Your Lordship, my senior is not present today, so that I have.
So senior is required for filing a reply.
No, it has been affirmed.
Taken up, always time is asked.
Why do you want to unnecessarily linger the matter? If you have filed, if you have served a copy, file it.
Only not today, I am praying for. Tomorrow I shall file, Your
Not
Lordship.
today means what? So many days.
He has not filed it, then what reply you will file? Let us see. Whether he files or not, we don't know. Not today. Tomorrow it will come. We'll see. Not today.
All right, 9.
Shiva, you appear on behalf of the state in this matter.
They're in a fixed case. I don't understand. He was claiming certain benefits. I said if you have earned the benefit, there's a case of grant of income. After the standard, I should get in January. Because for that joined in this year. In this year, January, so you tell us whether you got something from that code. So that
You are filing reply.
We have filed the reply, my lord. May it please, my lords.
On 6/5/18, you were, what was your age?
6/5. I was 18 years.
On 6/5/18.
18 years, 5 months.
Some died on 6/5/18. 16, 17. You applied for the next. You say that at the time of your father. Where is the rejection order by the authorities?
Rejection order page 60 and 61, my lord, of my writ petition. Sorry, yes, 62. I'm sorry, my lord, 62 and 63, my lords.
29/11/19. What is the date of the order?
Yes, 29 November 2019. My lords, on the other day, I placed a list of dates with corresponding page numbers.
So that's the only ground for rejecting, that you were a minor at the time of father's death. That
Yes,
is all.
I beg my lord's attention to the concerned notification in this regard. May I be
Which
free?
one? We have it. You tell us EMP number.
The one EMP, this is 2016,
EMP
1st
number.
of March 2016, EMP 26.
26. (2016).
Yes.
Yes.
I beg to draw my lord's attention to the amendment to clause 10AA. New clause added. Exceptional cases, my lords.
5 years, which they have said.
5 years. But the last line is very important. The dependent member
Which
must.
page? Which page?
It's internal page number 2 of the notification, my lord. The Gazette notification.
10A.
10AA. The one below that, my lords.
Belated request.
Belated request. And the last 3 lines, my lord. It reads as, the dependent member must invariably attend the minimum age of appointment at the time of consideration. May I? And the applicability of this notification, my lord.
Yes, this has come into existence much after your father had passed away.
Only 3 months, but not before my first brother. This notification came on 1st of March 2016.
Yes.
My elder brother applied on 7th March 2016, 7 days after this notification. But the applicability of this notification, my lord, internal page number 3, the last called 14BB. It clearly states, any undisposed cases where the death incapacitation has occurred prior to issue of this order, but after the issue of order number 30 EMP dated 2/4/2008 could be looked into afresh if complies with the revised instructions. You want it? For the timing. There's just one more page where I beg my lord's attention.
Yes.
That is page number 61, my lord, of my writ petition.
61.
61.
Yes.
My lords, there is one point A. Every candidate requires to fulfill all following eligibility criteria. The first eligibility criteria is of age. Age not less than 18 years and not more than 32 years as on 1/1/2019. So I have crossed that before appearing for the medical test, written interview, and the physical test.
No, these are not the ground. The only ground is you were a minor.
That was the minor of 2015. So the applicability of 2000 notification clearly states it's applicable since 2008. So 2015 will be covered within the EMP 26 2016. But this is an exceptional circumstances, compassionate ground, my lord. Honestly, I'm in a hand-to-mouth condition since 2015. And most importantly, since 2018, since my brother died.
And your mother is not eligible?
No, my mother is not eligible.
This fact is stated anywhere?
Yes, there is a affidavit to that extent of both my sister and my mother, which may be found in page number 91 of my writ petition. And the applications were both by my mother. My brother's application was also by my mother, and my application was also by my mother. My brother's application may be found in page number.
No, we being the wife and daughter have no objection. Where do you say we are not eligible?
No, 49, page number 49 is my brother's application by my mother.
No, anywhere she has said that she is not eligible.
She's not even, my lord, they belong to a scheduled tribe category. They're not even educated. My elder brother was only class 8 pass, which is an admitted fact, for which in my brother's application, it is clearly stated that a compassionate ground on any suitable post.
And your father was a constable?
My father was a constable. My father was a constable. My father's caste certificate is also there.
No, caste is not relevant. See, when it says special circumstance, you are relying on a...
Exactly.
Therefore, we are
Exactly.
asking you, it says one of the conditions is that no one else should be eligible. Therefore, we are asking you whether
Yes, because my mother was not eligible, which is why my mother made both the application, both for my brother and for me.
Yes.
Submit. Employee is dead. Application on behalf of his elder son. Should the elder son.
The petitioner, no, petitioner's mother.
Taposhi Mundal.
Oh,
The petition.
both have joined in this.
Both have joined.
Petitioner number had made an application for the elder son. He was class 8 pass. It was not eligible for the post of constable. He was eligible for the post of Group D staff. Your Lordship, in accordance with the regulation, Your Lordship, of compassionate appointment, for the appointment of Group D staff, that those appointments are made only on the basis of eligible, on the basis of vacant positions of the post. Your Lordship, I will kindly come to the annexure R1 of my opposition.
Here, filed here.
There was no affidavit filed before the tribunal.
What is R1?
R1 is the list of dependent employees. What is the waiting list? The waiting list for Group D, Your Lordship.
But that's not an issue.
His brother's name came way below, and his appointment or eligibility could not be superseded over the applications which were pending before it. Your Lordship, in the meantime, his brother unfortunately died. Your Lordship, thereafter, the petitioner number 2 made an application, Your Lordship. Your Lordship, the application has to be considered in view of the date of the death of the employee and not in view or in connection with the date of the applicant, Your Lordship. So when the authorities considered the same, Your Lordship, under the 2016 regulation, Your Lordship, not the belated request, but the timeline, 10A would be applicable in his case, which he did not comply. Your Lordship, 10AA would be applicable in those cases where there was no one else eligible for this post since the date of the death of the employee. But in the case, the brother had applied and there has been no averment whatsoever before the tribunal or before the this learned court that the widow was ineligible or not qualified for the post.
That's not your issue. That's not an objection raised
Your
by.
Lordship, our decision, the authority had decided on the fact
You are
that
only saying that he was a
he was
minor.
not eligible and that the application was time barred. Your Lordship, even if 2016 is taken into consideration, the applicable regulation will be 10A and not 10AA.
According to you, 10A applies, not 10AA. Yes. That's all.
Your Lordship,
Yes.
My lord, there'll be just one annexure of the affidavit in opposition where I may pray for my lord's attention. That is page number 31 of the affidavit in opposition.
You are Nitai Chandra.
Page 31 of the affidavit.
Yes, your name is?
My name is Mr. Mukherjee, Mr. Vishwarup Mukherjee.
No,
Jyoti Mondal, yes.
Jyotiman.
Yes.
So a positive recommendation in you.
My lord, the annexure that has been relied upon, which my lords be pleased to find in page number 30.
Yes.
They say I was below. They say I applied for constable, which I did not. I have drew my lord's attention to my application, my brother's application. The category that I have been considering was UR, unreserved category. Whereas I would have been considered on a ST category.
But no, it was your brother's candidature which was being,
Yes,
not yours.
No, my brother also had a same. My
No,
lord,
no.
the caste certificate comes from the father. My father
And
was
we have
an
understood,
ST.
but we are saying you were not pending in the.
No, I was not pending. I was not
your
pending. And
brother's
why this is an exceptional category under 10A and not 10A is because in the first place, if my brother would have been alive, I wouldn't have come into the picture. I did not apply for a job till my brother was alive. His unfortunate demise and the poverty that I am subjected to propelled me to place forth, which is why I am covered under 10AA and not 10A.
Yes, let us see 10A and 10AA. What is the date of death?
Of my brother?
No, your father's date of death.
October 2015.
Which give the date?
I will give the exact date.
19th October 2000.
19th October 2015.
2015.
15.
And your brother's death?
My brother's date is 5th May 2018.
5th or 6th May?
5th May.
5th May.
Oh, therefore, on 6th, you have applied when?
14th May, 14 June. My first application was 14 June
2018.
2018.
And the application made by your mother for your elder brother?
8th of March 2016. Page number 49.
And after your brother's demise, you yourself applied or your
No, my mother applied for me. Which may be found in page number 51 and 52 of my writ petition. Both my application. Was just 2 pages with corresponding page numbers I have given, my lords. They were loose sheets. Hi, much.
And which page is the rejection order at 62?
62, my lord. What?
Yeah. Is there any express statement that nobody else was qualified?
There is no express statement in both the application. It was my brother being the elder was nominated. We did not object to that then. My mother, once on his demise, placed me and they placed an affidavit that they were. And my mother is, honestly speaking, the petitioner number 1 did not even go to school.
And you were showing us that positive recommendation. Where is that?
Affidavit in opposition, page number 31. May I please, my lords? And draw your attention to why 10A won't be applicable to me. The last three lines, the last sentence reads as if no application is submitted within
We
the
are
said
not
period.
on 10A. We are asking you only on this because the impugned order contains a stipulation. It mentions that he is not the only person eligible. We don't know why they have recorded it.
In that
Therefore,
case,
we are asking.
in that case, the affidavit comes into picture. The affidavit that may be found in page number 91 of my.
That is what we are asking you. Show us from anywhere that there was no other person.
No, there was no other. My sister was married. My brother was elder. So they have clearly written, which is why they have not. That is the affidavit sworn before the first class judicial magistrate, page number 91 of my writ petition.
No, where does it say that there is no other eligible person in the family? This affidavit you have shown us earlier also.
Daughter was already married. Mother was 45 years age.
Mother's age is mentioned. Oh, yes.
In the affidavit, page number 92.
Then you are the only person. But you are SC.
ST.
So 40 years you are not ineligible. 40 is for you are in
I know,
compassionate appointment.
I know. I understand what my lords are indicating, but the situation was very different. It is my mother making the application, not anybody else.
There is a recommendation. Very
Much.
Matter number 110.
My lord, in this matter, my lord, the petitioner could not come to get the affidavit affirmed. My lord, I am praying for one more week's extension of time, my lord.
Why he is not interested?
No, no, my lord, he could not come. He stays in
Already we have extended it.
Yes, my lord, I know that, my lord. He could not come. He stays in the Midnapur town, little bit far interior. My lord, I'm praying for one last extension time period.
The time for filing.
The 111. In this matter, my lord, I am appearing on behalf of the petitioner. Unfortunately, suddenly there are.
Please use the mic.
Sorry?
Please use the mic.
Suddenly, my lord, the petitioner number 4 died in heart attack, my lord. I filed an application for substitution, which is pending.
Can one.
Can one.
Who is for the other side? This is 111.
Other side choose not to appear.
What is the date of demise?
Date of demise is 19 May 2025.
Yes.
And I filed the application
Not relevant. Yes.
on
The
number 112. My lord, I am for the petitioner, my lord. My lord, my senior. My lord, my senior Mr. Arindam Das is busy with another matter in code number 35, my lord. Kindly make it not today.
He wants the
process for district mass education extension officer.
be taken as the certificate.
3 years experience is mandated.
He is not qualifying the criteria as essential qualification criteria. He is not.
The experience.
Experience.
That's what we are saying. He says my email should be taken as experience.
That experience does not match with the essential qualification. Whatever we required in our advertisement, that is not matched.
Yes. That is why perhaps every day.
Come to our report, page 72. Page 72. Commission's report.
ये क्या फोन टा को देखी বাইরে যা তাড়াতাড়ি অর্ডার আরে অর্ডার পাস করে নিতে যা যাও
Last order. There are altogether 649 applicants has appeared for the post advertisement. Out of 614 candidates, list containing 190.
Now he is gone.
Oh, yes, he's gone to call the senior lord.
Sorry.
These cases, they should allow him to argue these
Yes.
cases.
Certainly, Malad. We should give preference to the junior.
জুনিয়র কে প্রেফারেন্স দিলেন তো আপনাকে
না জুনিয়র কে কল করতে গেছে
আপনি তো
আরে 35-এ আছেন উনি কল করতে গেছে
Sitting.
But he's coming.
not he's coming. What?
My lord, senior is coming this way.
Where's the email that he is relying upon?
Page 72. Page 72 of the report by the commission.
72.
Yes.
Commission's report filed before the tribunal.
73, your lordship can say. Petitioner accordingly submitted documents regarding his experience on 20th February 2020 and 23rd February 2020 On verification of the documents appeared, the documents claimed to be in the support of the petition. Experience was submitted within the time limit specified in the said notice issued by the commission.
একটু pass over. Lord sir, I'm paying for short pass over, my lord. He's just coming.
That is running over the next kind of person. Not possible. Make it
Today again, when the matter is taken up,
Let's start in.
Valid. I'm for the respondent, my lord, applicant before the learned tribunal.
I appeal for the petitioner in this matter, my lord.
Your lordship permit, may I recapitulate the fact, your lordship?
he is the petitioner.
Yes.
Lord, kindly recall, there was a submission.
No recall.
Yes. My lord, on 15th of May 2025,
Yes.
your lordship has been pleased to pass an order, my lord,
15th.
where your lordship has, my lord, directed the parties or, my lord, to the respondent concerned, my lord, to take instruction from each client, my lord, whether they have said anything about the inquiry. Because inquiry report there was an inquiry, my lord, and there, my lord, he has already submitted his representation and all that, and that was suppressed before the tribunal, my lord, and the order was passed.
No, my lord. I beg to differ.
Yes. Now, my lord, your lordship kindly says, my lord, the order which has been passed by the tribunal, there is, my lord, the tribunal has not dealt with the matter in a proper perspective, my lord. Why I'm saying so, my lord? If your lordship kindly says, my lord, that there was a serious lapses on the part of the, my lord, the respondent, because there was so many 7A cases, my lord. This was, my lord, under the Employees Provident Fund and Miscellaneous Provisions Act 1952, my lord. 7A proceeding was, my lord, he has initiated several 7A proceedings, my lord, but he has concluded, but he has not delivered judgment, my lord. Or sorry, the order, he has not passed the order in so many cases, my lord, and the new incumbent came, my lord, and he has decided the matter to the tune of 2 crores something, my lord. I can show, my lord, not only in one occasion, my lord, this has happened. This has happened in several occasions, my lord. If your lordship kindly says, my lord, he has, my lord, investigated such the
Paper book is there.
Paper book is there, my lord. As per the direction, my lord.
Apart from the paper book, my lord, your lordship was having passed the candidate direction on the date of hearing. What was the status of the inquiry proceedings? Because, my lord, your lordship, just to recall, I have submitted last occasion that at the time of moving the application before the learned tribunal, I prayed for interim order of the stay. This stay was not granted, but however, there was a direction not to culminate the proceedings. My lord, I'm reading that, my lord. Landed Council for the respondent, therefore, to take instruction whether 7A proceedings referred to at page 2526 Vide memo dated such and such, due to which the then Central Provident Fund Commissioner issued a warning to the applicant in terms of which the present charge sheet has been issued. The applicant may attend the proceedings without prejudice to his rights and contention. I would hope and trust that no final order would be passed in the matter till the next of the hearing. That was the order of the learned tribunal. Upon getting this order, my lord, I participated into the inquiry proceedings without prejudice, my lord. In the meanwhile, my lord, this particular inquiry report, the inquiry officer report submitted on 29 January 2024, my lord. The date of hearing, my lord, was fixed before the learned tribunal.
This should be bound.
Let's see the order of the tribunal.
Yes. It is a longish order, my lord, that is starts from page 241 and ends at page 286. 46 pages order, my lord. This is at volume 2.
Page
start from 241, you know.
Page
241, 241. Up to 286.
What the tribunal has done?
Well, it tribunal has taken into consideration on the self-same charges, because the 7A proceedings pilot, 7A was basically I was performing the quasi-judicial authority in order to adjudicate the 7A proceedings pilot. There was several impediment in order to adjudicate in finality due to the ensuing order of the Patna High Court. Then after mallet, these are the all predicaments which I preferred that when I was so caused, I given my clarification that under what circumstances I may not be able to adjudicate the 7A proceedings merit. Taking into account of my so cause reply to the so cause, the then disciplinary authority issued a warning, and that was suffice. Thereafter, my lord, after the passing of 4 years, when the new incumbent disciplinary authority came, there was a pit complaint, and on the basis of the vigilance report, they issued the charge sheet, pilot, for the self-same charges under which I have been given a warning, my lord.
So at that stage, you approached the tribunal?
Yes, sir. When the charge sheet was issued, I approached before the learned tribunal, my lord, and the tribunal was pleased to pass an order by
directing the charge memo.
No, at that point of time, the stay order was granted to the extent that I may proceed with the disciplinary proceedings, my lord.
No, the tribunal has ultimately quashed the charge memo.
Ultimately quashed the charge sheet.
On what ground?
Yes, my lord. The grounds, my lord, kindly, my lord, I'll pray your lordship to go from 265 pages onwards.
Tell us what are the grounds
on which, since on a self-same charges, when the earlier disciplinary authority has issued the warning, and there was no extraneous charges, nothing, my lord, and the impediment on the delay on the part of the adjudication of the 7A proceedings was on the basis of certain other factors.
Where is the charge memo?
Yes, my lord. Is that volume 1, my lord?
Yes.
Page 34.
84?
34. It consists of 6 articles of charges, my lord, identical, that non-passing of the 7A quasi-judicial order.
Statement of article of charges. And it show 1, page 34.
And since, my lord, I am raising the issue of the maintainability of this writ petition.
Maintainability?
Yes.
On
Why
what ground?
it is so valid? If your lordship will go to their prayer ballot, kindly come to page 312, what they're asking before this honorable bench ballot. I'm reading the prayer A. A writ of and oblique or in nature of mandamus, by setting aside the impugned order and judgment passed by the learned Central Administrative Tribunal, Kolkata bench, dated 20th/6/2024, and the competent authority to institute departmental inquiry against the respondent vide impugned charge memorandum dated such and such. I pause for a moment. this particular purported disciplinary proceedings, my lord, has already been culminated during the course of the trial before the learned tribunal. So therefore, there cannot be any prayer for the institution of the disciplinary proceedings, my lord.
What do you mean culminated?
Because they have passed they passed the inquiry officer report. Now they have to, DA has to take the call. So they are asking for the institute departmental inquiry. The institution has already been taken place by virtue of the issuance of the memorandum of charge sheet.
Yes. Page 34.
Yes, 34 the charge sheet.
What about?
It is 17 August 2020.
So 3 delay and 3 non-pronouncing.
Yes, my lord. And Lordship will go the earlier order by which the warning was issued. So in totality, your Lordship will get the picture. Kindly come to page 29, your Lordship.
This clause 5. Are these documents along with this letter?
I beg your pardon.
Page 29.
Yes, my lord.
You come to the 5th clause, complaints dated 7/8/15.
Yes, my lord.
Is that document here?
No, my lord, this document, my lord, I need to check, my lord.
What is this APFC?
Assistant Provident Fund Commissioner. my lord.
So he was the regional provident fund commissioner.
He was
Regional
he was
Provident Fund
performing the
Commissioner 2,
was a judicial authority.
not 1,
He
2.
was not the enforcement officer, my lord.
From this, it cannot be, it's not possible to ascertain whether it is the same issue or not. There are some complaints referred. What are these complaints? Nobody knows.
The other complaints, my lord.
One is by Super Kisan Udyog. There is no such mention in the charge memo.
Kindly come to the page 47, your lordship, in order to ascertain the nature of complaint under which the PTP or the Vigilance Commission has taken cognizance of that particular report, my lord.
No, the memorandum is there at page 32. How do you tally that they are for the same, in respect of the same allegation? That we are asking. That has led to issuance of a warning. Now it is for the same allegations. How do we gather it is from the same allegation?
That gather, my lord. But it the snippets of fact ballet is discussed at page 30, your lordship. When the disciplinary authority has taken into consideration of the charged officer or the applicant, my lord, the version response of Sri Pandey, an allegation against him was sought, and the allegation as contained in the aforesaid complaint were got investigated by the Vigilance Wing, Zonal Office Patna, and RO Patna. While the allegation levels against Sri Pandey were denied by him, the investigation into the said allegation suggested action against him for certain lapses, especially delay, failure in issuing final order after concluding inquiries under Section 7A of the APF and MP Act 1952 on careful examination of the allegation.
We again ask you, you said the tribunal has interfered because for the same charge, same charge, I was already visited with the penal consequence.
That is recorded in the order itself, my lord, by the tribunal.
That is the order under challenge.
Yes.
So,
So
that cannot be relied upon.
No, they have taken the facts, my lord.
Therefore, we are asking you, where is it? You tally it with page 30. 29, you tally it with the charge memo. Show us that it is the same charge.
The fact palette dealt with by the tribunal has taken into consideration.
Forget about tribunal's order. The correctness of that order is in issue here.
Yes, sir.
Therefore, we are asking you, show us that it is for the same charge.
Just. Just trying to get it.
Hmm.
Well, can you read page 47, Your Lordship? If thereafter, my lord, I will go. In the meanwhile, I'm telling my junior to look into those particular documents, my lord. Sir, biggest question. Both the charges are identical. এটা কি করে প্রমাণ করা যায়?
नहीं है नहीं है वो दूसरा कंप्लेंट है मेमोरेंडम और ये दूसरा मेमोरेंडम है सर
Issues are different. Bare reading of page 29 shows all the issues are different.
both memorandum yes
These are many various other things making adverse ACRs against subordinate on flimsy ground, adverse reporting against so and so, using influence to remain posted, recommendation of excess rent for new building in Bhagalpur office. All these are different allegations. How you are saying it is the same thing?
These are the allegation, my lord, under which this particular warning was issued.
Correct.
Subsequently, my lord, kindly come to 3321. Letter dated 3321, under which the narrow pretext, my lord, this particular charge was issued on the basis of the vigilance complaint, my lord.
See, you have said that the tribunal interfered because once the issue was given a quietus, there was no occasion to reiterate the issue. How the issues are same, we are asking you. Unless it is same, where does this point arise? That again it cannot be done. It is totally on different issues.
Correct.
We don't find any such issue that there is any delay in delivering any judgment, or that there is a non-delivery of judgment. There is not there in page 29. How the tribunal has found that the same issue has been given a quietus? Because it has relied on this 3/4/2017.
The ground mileage in my original application before the tribunal has taken to consideration by the tribunal. My lord, kindly peruses that.
You please come to page 282.
280?
282.
280.
Read the last paragraph undisputedly.
Yes. 282.
The wrong finding. The perverse finding. It's impossible to come to such a conclusion on the basis of this 3/4/17 communication.
In case the discussed area, and more particularly admission the part of the respondent that in year 2015, the disciplinary authority, competent authority has received a complaint against the applicant for not finalizing the 7A proceedings and had not passed final order after conclusion of the 7A proceedings for the year 20. Undisputedly, the state debt on the part of the applicant was made known to the competent authority in year 2015.
Conscious decision not to initiate proceeding by order 3/4/17. 3/4/17 is something else. Baseless finding without any basis, non-est. We have just seen 3/4/17. Those issues are alien to the issue arising from the charge memo, and at the bud, in the bud it has been nipped. Charge memo has been quashed. Three four 17 is at page 29. You see, that issue is not there. Any delayed passing of order or non-passing of order is not there to begin with. Six charges are totally alien charges. How different? How it has been done. Where's your OA?
OA malady starts from page
1 to 25, my lord.
The petition starts from page 4 of the volume 1, my lord.
1.
And the charge memo has been quashed. Such a limited scope for quashing a charge memo. And the tribunal has exercised jurisdiction. 42, 46 pages, whatever it may be. Unsustainable on a bare, just a plain reading, it is unsustainable. Forget about it. Anything else. And where is letter of the CVC dated 3/3/21?
Letter of the CVC, my lord.
Yes,
My lord,
3/3/21.
Page 47, also. 47.
legible copy is, my lord, page 47A.
Where is it? We don't find anything. There's nothing to do with the allegations for which the charge memo has been issued. So how do you sustain the tribunal's order?
You kindly come to page 275 of the tribunal's order.
That's why we are saying, how do you sustain the tribunal's order?
The second paragraph, my lord. It was the explanation of the applicant before the competent authority or the disciplinary authority at the relevant time that while he was working the RPFC 2, he did not finalize the 7A proceedings by issuing final order due to non-availability of the details or identified employees
Not
who
on
were
that.
enrolled.
We are on how do you sustain the tribunal's conclusion? How can you? Those issues were to be considered in the inquiry. Whether there was sufficient cause for not passing the order, whether a proceeding could be instituted having regard to the quasi-judicial nature of duties being assigned.
Yes, my lord.
That could have been an issue which may be required to be considered. We don't know because it's not before us.
No, because
He
that
says
is
no, already by this order it has been done. How the CBC has directed again cannot be done. You're comparing oranges with apples. How can you?
well, there was a no because the tribunal was having the mind, my lord, because there's a no any extraneous charges are not there. The person was
We
performing the
don't know
quasi.
what was in the mind is to be gathered from the order.
Even your lordship will go
We
by the
cannot gather anything other than from the order. We don't know what is in the mind of the tribunal and what is in the mind of the person issuing the charge. We have to go by the order as it is. There is no way a court can go into the mind. That is the reflection of the thought process in black and white.
Yes, even your
on
lordship,
pen and paper.
because since the discipline
3 for 2017 has nothing to do with it. This has nothing to do with the CVC's order. How he has connected, how the tribunal has connected the three things appears to be a baseless conclusion. Until now, you have not shown anything that they are either in any way it can be said that it is connected. All issues are other than passing of orders. There is not a single issue regarding passing of belated order or non-passing of order. It's not there. That appears to be the only ground. There is no other ground by the trial. The last is very clear. The unequivocal admission. Now it comes to an admission at page 285 on the part of the respondents. Just read para 17.3. That is the second last page at page 45. Thus the unequal admission. Where is the admission? How this issue is connected with 3/4/2017?
Admission on the part of the disciplinary objective with the level of complaint of is not instituted disciplinary proceedings significant to which the should
Getting 3/4/17 has no connection with 3/3/21 CVC letter. We have seen both. How the string has been, how a common thread has been found, we don't know. And on that basis, a charge memo has been, you go through the entire order. You go through the entire order, entire 46 pages. You go through it meticulously. We are giving you one opportunity. Prima facie, there appears to be a totally baseless order.
I'll try to satisfy Lordship on the comparison of the both the this mallet.
That we have already seen. Nothing can be said.
Yes.
We are only allowing you so that you may go through it's a very voluminous order. We don't know whether any other ground has been decided or not. That ground is clear as daylight. There's nothing.
And mallet, the second prayer with regard to the maintainability of the
That
petition.
we will consider whether that form of the prayer is.
Third mallet, the performance of the quasi judicial authority
Should
of
we
a person.
conclude it right now? We can conclude the hearing right now.
Just give me one chance to go
All
through.
right, then save your breath.
Yes.
Tomorrow we'll take.